Domicile. In the case of Tappan vs. Merchants National Bank, 19 Wallace, Chief Justice Waite says, personal property, in the absence of any law to the contrary, follows the person of the owner, and has its situs at his domicile. If the state has actual jurisdiction of the person of the owner, it operates directly upon him. If he is absent, and it has jurisdiction of the property, it operates upon him through his property. October Term, 1873, United States Supreme Court. The Commissioners, in their report, recommend that each assessable person be deemed to be domiciled, on the first day of May in each year, in that city or town within the Commonwealth in which he has resided the greater part of the 12 months preceding with the ordinary members of his household, and that all persons who have resided within the Commonwealth the greater part of the year, preceding the date of assessment, and all persons absent from the state who have gained no new domicile abroad, shall be deemed to be residents of this state. We have, then, Chief Justice Waite's decision in regard to the law regulating the situs of personal property, in the absence of any law to the contrary. We must see to it that the absent law is not wanting before another decision is asked for. The change recommended by the Commissioners might serve to discommode persons living out of town a short time during the summer season, and oblige them to go a little earlier or stay a little later to gain a residence. It would hardly accomplish anything in the way of reform. We doubt if it would save $1 from one place and place it in another, where it belonged, for the purpose of taxation. For the purpose of placing the domicile of the person, it may be as well as we can have it. But as we have before stated, property should not follow the person. Why should a taxpayer living in Nahant claim to be taxed for his property in Boston? Certainly not upon any principle of justice or protection. What has Nahant to do with this property? Can the taxpayer invest it in Nahant profitably? If so, and he does so, it should be taxed there. Is this property protected by the Nahant Police or Fire Department? Does it pass over the streets of Nahant? Is it stored in its storehouses? Not at all, says the merchant resident of Nahant. What we claim to be taxed upon there are evidences of credits, city bonds, railroad bonds, stocks of various kinds. Very well, say we, your property is protected where you have a lien for the payment of your securities. If in Boston, pay your tax there. If in Chicago, New York City, Portland, or Nahant, then pay your tax there. We have nothing to do with evidences of property relating to debts and credits, except through the debtor, so says equitable taxation. If there are securities held by citizens of this state, of property out of the state, it is there protected, and should there be taxed. If other states have bid higher for our capital than we can afford to pay, it is right it should go there, and there be taxed. One state should not seek to gain advantage over another one county, city, town, or person, in matters of government. The imaginary line of a state is nothing. We are a body politic, desiring the same equality in government, and having the same interests. It would be quite as reasonable for one partner to take advantage of another in matters pertaining to their mutual interests in business, as for one state to attempt to take advantage of another, in matters of government, in which their mutual interests are co-equivalent. If the several states of the Union would acknowledge these mutual interests to the extent of establishing an interstate system of taxation, based upon the principle of adopting the location of all property as its lawful situs, independent of the domicile of the owner, taxing directly all real and personal estate termed tangible, only, throughout the states upon any assessment they agreed upon, and enact the law of the debtors' lien, subjecting all taxpayers to its rights in every state, whether residents or non-residents, and also establish in each state a department of state tax commissioners, with duties similar to that of Massachusetts, and through these departments an interchange of facts in regard to non-resident property holders could be ascertained which would aid each department in assessing the income tax. This system, legalized by Congress, and made applicable to all the states in the Union, would be of the utmost importance in settling many vexed questions of law, while it would add many advantages to our general system of government. Such a system of interstate taxation would balance each state's accounts of taxes with the other. It would obviate all possibility of taxing one and the same property in two different states, or of the capitalist placing his spare funds in foreign stock for the purpose of concealment, thereby escaping taxation. Thus the law would become complete throughout the states, All tangible property would be assessed by the local assessors. The debtor would look after his taxes in the hands of his creditors, while the creditors were looking after payments, or interest money, and each would balance their accounts.